I'm Andy Kent. I'm Dean of the Faculty of Health, Social Care and Education, so I work, like a number of colleagues in the room, for two universities. That complicates it because they have slightly different procedures. So we're talking today about St George's procedures. I am using material and I've discussed with Professor Deborah Bowman, who's an ethicist and legally trained. My background is in psychiatry, and I have a lot of experience in that role, over 20 years of giving expert evidence to the courts and preparing reports. And I've been cross-examined many times in court with varying degrees of heat, including in the High Court. So I'll bring you a little bit of that experience today. But it's not like that. And that's very, very important because you can get caught out, as we'll see today, with lawyers involved, thinking you're suddenly in a courtroom. You're not. You're in St George's home. We're going to talk a little bit about the investigating officer role. And the investigating officer role is probably, and I don't know how many of you have done loads of investigating officer reports, or whether you've done the whole lot, like chaired panels or whatever. But if you haven't done much of this, the investigating officer role is a good way in to gain experience. And it's fascinating. Can be varying degrees of work, and we'll talk about the workload involved. And obviously, it's not how to be a detective, because everybody in this room has training and experience using critical skills, critical analysis, and that's the key skill, of course. Whether you're a scientist, you're in professional services, in my neck of the woods, we're trained, of course, to look at evidence and weigh the balance and put the arguments for and against, and that's essentially what the investigating officer's role is. And I was interested in that conversation, a very, very helpful conversation, a very interesting one, about classics degree versus, I'm doing a degree at the moment, and I only have to turn up to residentials because the accrediting body of that degree say that it has to be residentials that people turn up to. For 3 times in 3 years I had to turn up. They're not interested in whether I turn up any other time, not interested in whether I have to pass the exams to get the badge. And obviously, but this is different. This is saying, we can talk about, I'm sure we will, about attendance. That's a really interesting example because it gets into, well, so what? You know. Goodness me, I'm thinking back to when I was a medical student, whew. I get to the question of when does it become unprofessional? And of course, what you're saying in a fitness practice committee is not fit to study. You're not fit to be a radiographer, ever, anywhere in the world. And that is a profoundly kind of, it's a serious sanction, isn't it? You're not fit to be a physiotherapist, ever, anywhere in the world. You're not fit to be a doctor anywhere in the world. So it's a different question than actually about obtaining the degree, if you will. And of course, the most prolific serial killer of our time, I think of all time, is demonstration enough of the importance of the investigating officer getting it right. And the problem here, of course, is there wasn't much to go on at medical school. It was a little bit of soft evidence, and so it's very easy to look back retrospectively, but looking forward, that's the really difficult challenge, and that's why we have, of course, relatively sophisticated processes. So Dame Janet Smith saying, investigation is a task that requires considerable expertise. It certainly is, but the good news is the investigating officer, anybody in this room in different roles, is appointed by the principal. That means that the principal has confidence in you, and you are representing the principal in the university. So that's an important, happy thought to take with you. Doesn't mean to say it's going to be easy, but it is important to bear that in mind, that you are, if you will, selected and invited on the authority of the university. And of course it involves determination sometimes, but inquisitiveness and perseverance, absolutely. And getting to the various accounts, and it's not always easy. So some basic principles, the obvious one of courtesy and timeliness and consistency and trying to take an even-handed view. We'll come back to that in a moment. Fundamentally, of course, the question in relation to fitness to practice, we can talk about complaints, whatever, disciplinary. I was in a disciplinary at Kingston side on the panel yesterday, as opposed to facing the disciplinary. The fundamental issue let's take fitness to practice as the sharp end of the issue, although I suppose staff disciplinary would be equally relevant. You're talking about public safety, essentially. Okay, so if that person in front of you, are they fit to go and spend a lifetime working with in radiotherapy, with very, very, very dangerous, potential to cause harm very high. are they able to go and become an occupational therapist working with vulnerable people? So it's really quite a big question and quite a weighty question. Of course, if someone's done something like committed a murder, as Aileen was saying, we can kind of, sit back a bit because there'll be a criminal investigation. We're not going to be doing anything until that's all over. And the nice thing about courts is they decide facts. And once the judge has decided a fact, Robert will take us through this more expertly later, that's a fact. So there's some nuances there that you're going to go into. And burden of proof is something I'm going to talk about as well. So we're in the more soft territory as the investigating officer where it isn't clear cut, so it isn't straightforward, and that inevitably involves judgment. So obviously we're all trained to be rigorous, we must focus on facts, try not to bring our own opinion into the matter, and of course we're trying to get a handle on who all the interested parties are. And I think here, of course, you have to exercise some judgment about how far you're going to go, how many people you're going to interview, how much time you're going to take to answer what may be a relatively straightforward question. So there's a judgment call there. But the good thing about being an investigating officer is you're not actually upfront and personal with a lawyer, for example, in the hearing. You've got the whole army of talent here at St George's, Rachel's team particularly, helping you. So you've got a huge amount of guidance. There are a huge library of previous investigating officer reports that you can have access to. There's probably nothing that hasn't been examined by an investigating officer in our 280-year history. So there's a wealth of material available to you. And of course, you will have somebody going to interviews with you who is trained to clerk the meeting and typically will audio record it. So it might be Rachel or one of her team, but it's a very kind of safe and constrained process. But you have to make the key decisions on part of the university. So, obviously, transparency is very important, and we might talk a little bit in a moment about how one would approach the actual interview. Provision of support is critical. So, as in all things with our students, when writing to them, telling them something that may be difficult for them to hear, it's important to remind them of their rights to have somebody supporting them, whoever that may be. And this is basically, of course, common sense, inequalities, diversity and inclusion, Equality Act, etc., but natural justice to you and me. So if someone is facing a very, very serious allegation, they're inevitably on the back foot and potentially very nervous, and so at a great disadvantage. And so as the investigating officer, you need to make sure that they know and understand their right to support, because that's critical. And of course, there may be consequences for them in terms of needing access to specialist support, like counselling support. Fundamentally, of course, you're accountable for explaining your recommendations. And it is essentially three things that you'll be recommending in a fitness to practice hearing. No case to answer. I've looked at this, experienced professional that I am, and I cannot see what the fuss is about, okay, put it bluntly. Or, well, there's something here, but it can be dealt with through informal means. And if you decide that, of course, that doesn't mean to say the train stops and everyone gets off, because there is an ongoing process of support, and if further problems come to light, then the process can be reactivated and restarted. And then, the third and final one, and essentially all you have to do is to say, I think this matter should be referred to a hearing committee. And that essentially is job done, okay? And then I would encourage you, if you haven't done it, and you've done some investigating officer reports, to do the presenting officer report, which Robert's going to talk about, gets a bit more exciting, potentially. Fairness, okay? The opportunity to challenge and appeal. Once again, Rachel's team will hold our hands as they hold mine. So there are timelines, there are sort of statutory with a small s expectations of how much time the student has to receive and process the content of your report. And all of that is kind of, if you will, process that the team, the university, looks after. But it's absolutely critical that the student gets the opportunity to assimilate the arguments and provide their defence. So some of the pitfalls are obviously inconsistency, and this happens in all walks of life, that you perhaps, and variation I suppose comes into that, you give more attention and more detail to something rather than another, and I often find that quite difficult. And certainly having been both investigating officer, presenting officer, and panel chair and panel member, you sometimes think, well, interesting that I was in one very recently, a few weeks ago, where clearly the student and the lawyer, and I'm not going to give you the detail of the case, fascinating that it was, student and the lawyer clearly thought that what we were really concerned about was that. It wasn't that at all. It was something entirely different. In fact, to cut to the chase, what we were concerned about was integrity and probity. Whether that had happened was, to some extent, well, that happens. And we just need to be sort of, as the investigating officer, really balanced and to some extent allow the decision about what is the really important thing in the array of evidence for the presenting officer and the panel if it becomes a bit murky. Well, the interviewing and writing reports, this is really just a question of, I suppose, if you're, I guess most of us probably have lots of experience here, but as I say, there are some excellent templates, and I've found my reports changing having read colleagues' reports, and you know, we're evolving to kind of a model report structure, so it's out there for you. And it's actually very straightforward. We've got an example, a sort of a shorter example in the paperwork for you. Interviewing, I think I'm going to come back to that, but we'll tackle that. And then probably, you know, what you delegate and what you not. Probably as an investigating officer, rarely going to delegate anything, except on Rachel's device to one of her team, perhaps. When it gets a bit tricky, not seeking advice, I remember when I was at, gosh, I'm on camera, I better not give you stories of when I was a junior doctor and I didn't seek advice. We'll pass swiftly on, but one of my problems as a junior doctor was thinking, I daren't ask for advice, they're going to be cross with me because it's 3 in the morning, when actually they were cross that I didn't ask advice in 3 in the morning. Nobody came to harm. But that was my flaw, as you know, growing up, was not asking advice when I needed it. And I think it's just very easy. Pick up the phone to Rachel, put you in touch with a colleague. There's plenty of people who can give advice. Not adhering to timescales or requesting more time. This is another one. You know, you don't want to, as I've done more than once, be writing a report at 3 in the morning. I once wrote a report in Children's Act proceedings, you know, regarding the potential removal of a baby, and I sent the report at 2 in the morning, and the barrister for mum or dad said, I see Professor Kent's report was submitted at 2 in the morning. You don't want to be in that position, you know, so it's life, it's a marathon, not a sprint. So if you need more time, then it's reasonable to request it, because sometimes there's more involved than you think, not always. Clearly, being objective, not having a favoured party who's giving a view. Quite tricky sometimes, because we're all prone to being subjective in our impressions of people. But I think really the kind of, what's the mantra from that famous 60s police show, just the facts, you know, try and be as neutral as possible. And obviously don't try and stretch your conclusions. The nice thing about being an investigating officer is you can take it so far, and then some degree of interpretation may happen downstream of your report. Keeping people in touch. Once again, Rachel and the team will absolutely keep you on track with that, making people informed of what's happened. And then misunderstanding or placing insufficient emphasis on one concern versus another. That's actually a rare problem, and if in doubt, ask. Clearly, and it's in the guidance, which is in the handout, you have when invited to do it, because of course, you know, it may be August and everyone's away and you are a nice, able, experienced assessor. Are you the right person? So if you've had a lot of involvement with a particular student, I would suggest not. If you've given the occasional lecture to the radiography students, perhaps once every other year, you're probably fine. It's the degree of proximity to the student. If you're their personal tutor, absolutely not. So that's a judgment call. Do think about conflicts of interest, whether you can complete the investigation. Obviously, we're in the business of encouraging colleagues to become investigating officers. It is actually a very important role, and it's quite a rewarding role, given the stakes sometimes. But if workload is a problem, you'll need to think about that. The question of what you're being asked to investigate, is it something you can take a view on? I guess, you know, without being divisive about it, some issues may have a very clinical spin to them, fitness to practice. So you might take the view, if you were not a clinician, that the question of fitness to practice in the clinical domain was one that you might say, well, I'm not sure I'm the right person for that. It might be that you're invited to take a view as an investigating officer to do a report on a student from one particular discipline and you're from another particular discipline. So in my instance, as a medic, I would think carefully about whether I was qualified to take a view on physiotherapy. But usually, that's not an issue, because if we set the standards and expectations are essentially the same. But those are the kind of questions you might want to ask yourself. What relevant information do you already have? There's no point in reinventing the wheel. What relevant information should you seek? And that is really, I think, part of the art of this, is how many interviews do you need to undertake? And it's rare to take them more than 2 or 3. Sometimes it might just be 1 interview. But good investigating officer reports demonstrate a degree of kind of rigour in relation to, well, the report we've got, the person working behind the student bar has a view on what's happened, and the investigating officer goes and interviews that person to get their impression of that information. And is there anything you need in addition without protracting the process? Once again, these are up there for information for us to talk about, but Rachel and the team have a huge amount of experience and can answer any question you're likely to have. Basic rules: the older the evidence, the less reliable it's likely to be. That's, you know, in the short lifespan of a student career at St George's, that's not often the case. Whether it's appropriate to include previous information, I was in a hearing not long ago where the presenting officer brought new information in that said, that's not actually quite true. There was an incident, blah, blah, blah. And then we were very clear, well, you know, that information, there's no documented record of that, whatever. So if, for example, there's a suggestion of previous behaviours which have been problematic, you really want to assess how relevant they are. And that might mean, well, how relevant were they at the time? If they didn't trigger a record in the student's file, or if they didn't trigger an inquiry, should they be included? So you need to be judicious and fair in relation to that. And information that's not supported by evidence has less weight than that which can be. This is where hearsay becomes a problem. The important, and I know Robert's going to talk about this, the important thing to bear in mind at all times is this is not a criminal investigation. It is not a court of law where this is going to be discussed. It's a university committee. So there's a degree of flexibility, and I know Robert's going to talk about that. But common sense about what you should possibly include. And the difficulty you have, you see, if you include information which is weak and possibly irrelevant, then it may undermine the university's position when the university actually had a strong case. Having said that, your report will be reviewed before it's submitted, and of course it is submitted on behalf of the principal. Planning, very important. Think about who you should speak. You might want to have a draft of interviewees and the deadlines, a little bit of project management, and keep a record of all contacts relating to the investigation. So basic principles of good note-keeping. Preparation and planning, so know what you're going to ask. Obviously, sometimes students can take you into interesting territory. They might sometimes grab a spade and start digging. And sometimes you have to follow them down that particular rabbit hole because it becomes more important maybe than the thing that was the first thing you asked about. Engagement and explanation, we'll come back to it, but my approach is absolute respect to everybody. I know everybody in this room would agree with that. What my old boss used to call unreasonable reasonableness at all times. You want to get the best for the student, but you most importantly want to get the best for the general public over the next 40 years of that person's career. So engage, get the best from them, put them at ease, explain what's happening, check that everyone's comfortable. Then you want to obviously get the account, close the interview. I always ask, is there anything else you want to say? How was that for you, essentially? Was that okay for you, that interview? Did you feel that it was conducted in any way unfairly? This is very powerful stuff when it comes later and someone starts to challenge the merits of the particular approach you've taken. And then go away and evaluate your evidence and put it into your report. And we'll come back to that in the workshop. So sometimes you've got a vulnerable or potentially unwell participant, and I've already talked about trying to minimise distress, but sometimes you just have to defer until the student is in a much better position. Having said that, we've had examples, a recent one which I was involved in, where a student's lawyer said they were not fit to be interviewed. Okay, and so there, what we do is we ask our wonderful in-house psychiatrist, Dr. Frances Raphael, to take a view. And in that instance, she said, the student is fit to be interviewed, and we proceed. But you can see if you said no, if you took a view on that, you might be more vulnerable subsequently. So we've got resources to address things like that. Of course, there are personal tutors and counsellors to involve, and the interface between conduct and health is a very problematic one. And as Aileen said, not untypically, we see people bringing health arguments in very late in the day. Very different if a health argument is brought in early. We can deal with that. So one approach is to treat everything that's very serious as a disciplinary matter and let the health argument surface and be dealt with rather than be distracted. Reluctant participant, well, this is something where essentially if you're not cooperating, you're once again digging a little bit of a hole for yourself, because at the end of the day, if your recommendation is that this needs to go to a panel because I've not been able to engage the student, it will be dealt with that way. Request to speak off the record. I would counsel you to never agree to a request like that because you cannot unknow information. Obviously, I've over 30 years, patients saying to me, can I tell you something in strictest confidence? And I say, in clinical work, you can, but if you're going to tell me something that I have to report to other people, like you're planning to kill your next door neighbour, or you're going to kill yourself, I will breach your confidentiality. Now, obviously that's a little bit dramatic, but I don't think in this environment you ever need to be exposed to that risk. So I think to say that I'm unable to take anything off the record, anything you say potentially is on the record, is a reasonable way forward. Lawyers. Increasingly, students are bringing lawyers to the hearing, and if you were a student in that situation, wouldn't you try and get the best lawyer you could afford and bring them along? I know I would. So I personally welcome the involvement of lawyers. I think it's about the fairness to the student and their representation. However, whoever is coming along to support, even if it be a QC, which would presumably be relatively unlikely, they're not able to take over the interview. It's your interview. You just have to remind them, you're here to support the student, I'm here to get the student's account. The police don't have the lawyers answering all the questions, we've seen it all on telly. The student's account that's important. So remember, it's not a court of law, lawyers can't play any legal tricks, it's very straightforward. You're trying to conduct an investigation and they mustn't hamper it. Sometimes you can have a representative who's not there really at the request of the student, and you might just want to check out with the student that they're comfortable if you've got any concerns. So bullying and harassment cases, we've talked about racism, which I think was a very interesting question. I was involved in a case of an allegation with that this week in relation to another matter. And of course, bullying and harassment, all kinds of things where we probably as a university think that we have a zero tolerance policy. And of course the investigating officer's job is not to demonstrate a zero tolerance policy to these things, it's to establish as far as he or she is able what actually happened, what's the materiality of the allegation, etc. And at some point you might have to make a judgment about that. But we have a raft of policy guidance, and so really it's essentially making sure you're comfortable with the territory. I think sometimes, just thinking aloud here a little bit, you may in the course of an investigation, if you were to uncover information of concern, like someone was stalking somebody or being stalked, you would seek advice about whether that was a matter that needed to be escalated. It's rare in my experience, but there will be times where you might uncover information that requires other action. And getting as much information as possible about an alleged incident is quite important, because later on, of course, it'll be dissected in some detail. In relation to writing reports, by the way, I came across very early on in my medical career, well, I saw something happen which, you have to remember, I always think anything you write in a report, like anything you write in a patient's notes or anything you write in a student file, I always think, imagine a high court reading it. That's my kind of rule of thumb. You can't really go wrong if you're thinking about, what it would read to an experienced judge. My experience, judges, well, obviously incredibly clever, but my experience has been overwhelmingly positive and sensible people who really, really can see through most things through experience. I've already mentioned the issue of escalation, but if there's something ongoing or if someone's been traumatized, then you might want to think about what further support can be offered. But once again, there are lots of us about who can help with advice. The impossible case, you just can't get there. I was once involved in a court case where I was giving expert evidence, and you just could not tell what was going on. It was driving me mad. The facts were shifting, different explanations, the couple involved had opposing stories, then they agree, blah, blah. I thought, well, this is just impossible. How can anyone know what to do here? And the judge said, it's impossible to know what's going on here. That is a very big worry to me. And therefore, I'm leaning towards taking this action. So when obviously something is confusing, it usually means there's something going on that you need to get to the bottom of, and if you can't get to the bottom of it, you have to demonstrate reasonable efforts to have done so, and then I think it's over to the hearing committee and the presenting officer to take a further view. You need to be rigorous with yourself, but also rigorous with other people involved in limits and the reasons for them. And essentially, you might end up having to make a recommendation on the basis of your experience as the principal's appointed officer and take a common sense view. As I've said, investigating officer's job is to say there's no case to answer. This can be dealt with through informal procedures, or this goes to a hearing. Clearly, you're a very important person all of a sudden, catapulted into the life of the student, maybe into the life of their lawyer, into the life of their family. You need to be clear about your role. You're there to take a reasoned view on behalf of the university about what has happened and whether this needs to go one of those three routes. It's very unusual to have too much pressure on you as the investigating officer. That's not necessarily true of the presenting officer, which we'll come to, but just stick to your guns. You clearly may come to some very unwelcome findings that's going to result in the expulsion potentially of that student. So your opinion is going to be critical to that student's future. But you're doing it in good faith, which I think is always important to bear in mind, and you need to just basically stick to your guns. Remain calm, being unreasonably reasonable, being always courteous. So when I'm doing the presenting officer role, I will typically say, and I'm sure Robert will come to it, I may say some things to the student that will be uncomfortable to hear. Do forgive me for that. Little things like that go a long way to demonstrating your reasonableness. I may in my report say some things you might find a little hard to read. That may or may not be the case, but just doing my job. So, a lovely quote from Cervantes, fair and softly goes far. So if you're calm, fair, reasonable, able to be a bit flexible in the role, that counts a lot.